Good evening. I'm Attorney Lawrence Berliner, an attorney in the field of special education law. Tonight, I'm also with our co-host, Jane Faherty, who is the director of the JumpStart program and an advocate in the field of special education as well. We're honored again to have Allie Grafman, an advocate of ABC Advocacy, one of our returning champions. So we're very happy to have her again. We have a roundtable format tonight. We have a bunch of questions, about 2 pages so far. I'm sorry, Jane and I, we're doing this, our 5th year now, are continuing to present these webinars because we're part of a community of concerned parents and professionals still learning how, especially in the past 24 hours, how to connect with one another and deal with changes in special education law that's going as we speak down in Washington and to a certain degree in Hartford, the capital of Connecticut. We are honored to have many people from other states and countries. Our focus is on Connecticut law, so if you're from another country or another state, please check your local jurisdiction because the laws might differ from what we have here in Connecticut. We are continuing to address the social and emotional educational impact of your child's educational journey. And as I mentioned before, because of the past 24 hours announcements that have been made, that journey and tonight's webinar is quite relevant to figuring out how to get to the other side. And we'll go over a lot of questions, understanding your child's educational rights, parents' input, PPT meetings, that's IEP in other states, but we call them PPT meetings, summer programming, eligibility, other issues as they come up during tonight's webinar. If we ask that you put any questions in the Q&A function at the bottom of the computer screen, and I'll get to that in a moment. We have information in the chat section. The chat section will be recorded. So if you don't want your comments or name recorded, please put it in the Q&A section, which is not recorded. The webinar is recorded. A copy of the webinar will be provided for each person who has registered after this evening. The information in the webinar does not constitute specific legal, education, or professional advice regarding you or your child and should not be relied upon such. The webinar does not establish an attorney-client relationship with Attorney Berliner, myself, a professional relationship with Jane Faherty, the Stamford Jewish Community Center, Allie Grafman of ABC Advocacy. By signing up, you've agreed to receive emails about future webinars and events from Jane Faherty, Stamford JCC, myself, Lawrence Berliner. Zoom is a third-party provider, not an agent of or associated with the law office of Lawrence Berliner, Jane Faherty, Stamford Jewish Community Center, Allie Grafman, and the information provided is based upon Connecticut law, policies, and to the extent federal law as well. So Jane, it's been about a month or so since we were together, and a lot has happened. I know you just returned from a national conference, so you want to share any preliminary thoughts before we introduce Allie?
Hi, good evening. It's nice to see everybody again, and I can't believe it is 5 years since we started this lovely conversation. And just as we got over the hangover of COVID, we've embarked upon another tailspin. But I do want to reassure everybody that if you are in Connecticut, we are relatively fortunate in terms of some of the provisions that we do have enshrined in our state policies and laws. And Lawrence can reassure us on that in more detail. But one of the conversations, I've just returned from a convention with the Council of Parents, Advocates and Attorneys, which is a wonderful organization that I would encourage you, if possible, to participate in if you want to remain updated on some of the changing landscape within education, particularly on a federal level, more so than a state level. But one of the takeaways I had is that if you are feeling unsettled at this time and unsure about changes that may or may not be happening on a local level within your district, if there is an opportunity that arises for you to have access to maybe participating in board meetings or attending board meetings and engaging in your local conversation at a school district level, that might help reassure you and also embolden you to advocate for yourself if you see things starting to shift in a direction you're not comfortable with. And also another thing that I recommend you do too is become familiar with the budgets that are established in your local school district, and pay attention as to where some of those resources are allocated. This hopefully will reassure you, and if you have any questions about what your district is doing, it will give you a chance to ask more informed questions and hopefully elicit more detailed answers from them too. So that's my biggest takeaway, is that we have to advocate for our children, but if we come together in our communities and our local communities, we can come together as one voice and maybe have a greater impact to continue to move forward and make sure the provisions and the things we care about remain intact for our children and those around us as well. So we're lucky to be living where we are. I was very glad when you hear the horror stories of what's happening in Missouri or other states that are elsewhere in the country. I feel comfortable to be located here. But other than that, it's lovely to have Allie back tonight at this time to do this roundtable where we're looking to answer a variety of questions with regard to advocacy and obviously with Lawrence legal insight. So hello, Allie.
Good evening, everybody. I'm Allie Grafman. I am a special education advocate, and I'm the director of ABC Advocacy, LLC. It's great to understand that we have a huge crowd tonight, and I think it's perfect timing because of the uncertainty of what is going on and at our national level as well as our local levels. Advocacy at this point is certainly a priority, because at this time we have to ensure that our kids, your children, our community in schools are allocating, as Jane said, the resources that are needed for to support our kids. So when we are at our IEP meetings or PPT meetings or even team meetings, whatever we can do to advocate and make sure that our voice is heard, that we advocate for what the student needs, not for how much it costs. And I think that's an important understanding that, yes, we know resources are certainly at a level of uncertainty, but we also know that many of our kids are needy and they are entitled. They are entitled to services and programs. So it is a high stakes time at this point, and we hope that through this webinar we can answer your questions and you can feel more settled and secure. Thank you.
Thank you both. One of the questions, it's sort of the elephant in the room that we received from one of our participants, is what are the differences that are going to occur with the changes at the United States Department of Education? This is a question that came in to all three of us from a parent or professional, whoever sent that. Thank you for the question, because in the past 24 hours, it's become more relevant as we're starting to see the impact of executive orders and policy changes. And I'll just start with, we learned yesterday that half of the staff at the United States Department of Education are going to be terminated. And these aren't people just in Washington. These are people spread all over the country. And we learned also that the Office for Civil Rights, known as OCR, which is a civil rights enforcement agency or division within the Department of Education, has had their workforce slashed significantly, and they're closing regional OCR offices in New York, Boston, which covers the New England states, I believe San Francisco, and possibly others. So a lot of the civil rights enforcement activity will change. Whether it will be eliminated, I don't know. Whether it will be shifted to another federal agency, I don't know. That's still a work in process. The other thing is funding. A lot of the discretionary funding for grants have been frozen or eliminated. Allie correctly talked about entitlements. There are certain programs like the federal special education funding right now today is an entitlement. Title I, another entitlement. Will that change? We don't know, but we know there are people within the current administration looking at cutting these funds. And I just want to end with my remark, and Allie and Jane, please add to that answer to that question. In Connecticut, we're very fortunate to have Senator Chris Murphy, who sits on a committee of cognizance, which means he's on the Health, Education, Labor, and Pension Committee, known as HELP. Please call or write your congresspeople, your senators. If you're from Connecticut, we know Chris Murphy and Senator Blumenthal will vote the right way, but they need to hear from you, especially parents, that how these impacts are going to affect you as families, your children, your communities. In addition, Rosa DeLauro, who is a United States representative from the 3rd District, which covers the greater New Haven area, is on the Appropriations Committee, money, funding. Write to her or write to your own United States representative, because we have a very good congressional delegation from Connecticut, 5 representatives, 2 United States senators that are all speaking with one voice on behalf of the people of Connecticut. And that should be telegraphed not only throughout Connecticut, but the other states from people. Please stay involved. Don't give up. Stay involved by contacting your elected officials. And I might also add that also goes for our state representatives and our state senators, because there is legislation and budgets being prepared in Hartford, the capital of Connecticut. So you should be attuned to what's going on the state level, and especially attuned to what's going on the national level.
I would just like to reassure everybody too that when you hear about executive orders, remember that they're not legally binding. So an executive order is not enforceable until it has gone through a certain process and certain steps and procedures. So I don't want people to unnecessarily get upset or anxious about an executive order. Particularly where we have some great legislatures that are putting things in place to protect our civil rights and to protect your rights and your children's rights. So I don't want anybody to get too upset about that. And in terms of if you want to get engaged but are unsure, unconfident as to how to communicate with your local representatives or even your school board, you might be able to find template letters that you could use. You might also be able to find examples of testimony and anecdotal stories, which are also impactful, powerful ways to connect and communicate your story and your child's needs with those in the legislative branches, so that they understand really what's going on at the grassroots level. But there are platforms and templates you can use so that you don't feel overwhelmed with how to communicate your concerns either.
Allie, anything to add to that? No, I think the two of you summarized it beautifully. My takeaway from all this is we don't want couch potatoes. I think we need to get up off the couch and become active, especially if you have concerns with your child or anybody that you feel needs the support within the schools. Engagement, being on committees within the schools, communicating, all of that is essential during this time. So become active and have your antenna up, because you are the voice, and you need to be heard. It's a village, and you know that saying, it's a village, and we need every voice in the village to become engaged.
That's excellent advice. And I'll also add to that, March Madness is not only confined to basketball, it's to what we're talking about tonight as well.
Well, I have a question, Lawrence, that came in earlier today. How would you recommend that parents go about tuition reimbursements when they do lateral placements?
It's a good question. It's sort of putting the question sort of puts the cart before the horse. There's a process. We have to start with a determination of eligibility for special education. That usually requires an evaluation, public or private. In Connecticut, we have PPT meetings that determine eligibility, review evaluations, determine eligibility, and write an IEP, an individual education plan. And the school districts have an obligation to provide a free, appropriate public education in what's called the least restrictive environment. The least restrictive environment is a presumption. And what the law presumes is that children with disabilities will be educated alongside children without disabilities to the maximum extent appropriate. And at that point in the regulation, there's a comma or a semicolon. And it goes on, unless the child cannot derive satisfactory benefit. And then we start looking at what's called a continuum of alternate placements. So we always start with a regular classroom, the neighborhood school. That's our starting point. Sometimes we have to use a resource room combined with a regular classroom. Sometimes we have a self-contained program. Sometimes there's a school across town that may have a better array of services than the neighborhood school. And if all of that is not working, then we start looking at further out on the continuum, out of district placements. So if a parent has made a unilateral placement, that means a parent placement without the PPT, you can't skip over all the other steps. The child has to have an IEP. The IEP, we have to establish it's appropriate or not appropriate. If it's not appropriate, that's when we start having a dialogue on whether or not the child should be in another placement, an out-of-district placement. If the PPT decides that the child can receive the free appropriate public education in a private special ed school, then the school district will pay for that school. On the other hand, if the PPT denies the parent's request, there is a process of dispute resolution. Some people use the State Department of Education mediation program to discuss their concerns with a third-party mediator, and maybe the two sides can reach an agreement in between the school's position and the parent's position. Some parents, especially when I'm involved, file a request for a due process hearing, which is a formal administrative hearing. And we get another kind of settlement meeting called a resolution meeting. The same process. Can we find something in the middle of the school's position and the parent's position that both sides can buy into? If that doesn't happen, then we proceed to the hearing. It's a trial. It's an administrative trial with an independent hearing officer. It's a very formal proceeding. It's advisable to have an attorney present representing the parents, because you can be rest assured there'll be an attorney representing the school district. Both sides present their case. The hearing officer will decide which party prevails. Fancy way of saying you win. If the parents prevail, then the school will have to do whatever the hearing officer orders. So if this is about tuition reimbursement and the hearing officer rules in favor of the family, then that's how the parents will receive reimbursement. Most of the time, it's settlement discussions, either through mediation, resolution meeting, or sometimes just lawyer to lawyer negotiations that allow the parties to reach a compromise. Otherwise, we end up in litigation. So that's how a unilateral or parent-initiated placement could be reimbursed. PPT, placement, if not negotiations, if not litigation.
We just had a question that came in that asked how much will a reduction in federal funds, potential federal funds, impact out of district placements? And I could be wrong, Lawrence, but I think in the state of Connecticut, less than 10% of the funding for education comes from federal grants and money. Is that your understanding?
That's mine. I read something earlier today. I think the State Department of Education issued some kind of press release or announcement, and it was less than 10%, maybe 8%. But that's overall funding. Special education funding might be closer to maybe 15% of a school budget, but the overall federal funding is probably less than 10%. So what will happen if the federal funding is eliminated or reduced? It's going to back up on the state budget. And if the state cuts its educational cost sharing grants and special ed reimbursements, then that's going to back up on the local budget. And either we have two ways of solving budgetary problems. We cut spending or raise taxes. Both of them are potentially unpalatable. So that's why it's very important to be involved on the local level, the state level, and the federal level to make sure students with disabilities are not losing out disproportionately to other members of the student population.
And just to put in perspective, I think 17.1% of students in the state of Connecticut receive special education services of some description or other. So you're not alone in your concerns, and there's plenty of other parents that are going to be feeling the same things as you. So connecting, engaging together and unifying in your voice is very productive. But Allie, I have a question for you that came in earlier. What can a parent do if they wish and feel their child needs some kind of evaluation? What steps should they take?
Well, if they need an evaluation, I guess you'd have to back up again and look at why, okay? What are the needs of this child that are not being met within the school? So you would look at the data. First, you would want to see if this child has made progress or if it's regressed and so forth. So you look at the data. If the student is already in special education, you do get your progress monitoring forms, and many schools give it either quarterly or triannually, 3 times a year. But you can use those forms to see if your child is making progress on his or her goal and objectives. So if he or she is not making progress on those goals, so that's one data point to look at. There's other data points to look at. There's the state, the SPEC, the state approved the state approved benchmark performance tests. So that will tell you if your child is making state level qualifications that meet the state standards. If he or she is not making those state standards, then that's another data point to look at. Report cards are also, valuable pieces of information, as well as teacher reports and observations. So taking all of those informative pieces, you have to look at it as a whole, not one piece of information tells the whole story. So you look at everything together, and then you say, well, something is going on here that, my child isn't making progress, adequate progress, or they're below state standards and so forth. That's when you go to a PPT and request an evaluation. Depending upon what areas are the most concern or are the concerns, then you look at what evaluations are most appropriate, and that will be decided by the PPT, the team, including you as a parent or as a guardian.
That's really some great advice, Ali. The other thing, and this is just a side note, at the convention I went to a fascinating workshop on AI and the virtues and the pitfalls of AI when it comes to special education. And what is interesting is there are some AI platforms out there that are being promoted to special education teachers to help them develop and create goals and objectives for students. So all I would say too is when you are reviewing IEPs or progress reports, really pay attention to make sure that they are about your child and relate to real factual provision of data embedded within it, because these AI platforms are quite remarkable that they can generate what looks to be very valuable goals and objectives, but they might not be relevant to your child because you could just put in quite a generic word or description that might not be relevant to who your child is and how they are currently performing or their specific needs. Some of these AI pieces are also generating accommodations or modifications that are not truly accommodations or modifications. So I'm not saying that's necessarily being used pervasively in our community, but it certainly is something that teachers are becoming more aware of. So we just need to make sure the devil is in the detail and they're about your specific child.
And I can add, one of our questions this evening is what kind of documentation can parents expect to receive? And both Allie and Jane have explained that. The IEP document, the progress monitoring document. I'll add to that work samples, what you see at home. If a child has supposedly learned something at school, are you able to see that generalized to home or other settings? And it's very important to read the documents. Don't assume the documents are accurate. And I add to that, if the record of the PPT meeting or there's information in a school evaluation report that's not accurate, send an email so you have a written record that I disagree, or this statement is not accurate, or I made this request that's not in the record of the PPT meeting. So it's important to read the documents. It's important to make sure you understand the documents. And as Jane is pointing out, in this exciting or unexciting world of artificial intelligence, make sure the documents are individualized. It's an individualized education plan. It's tailored to your child, not some generic platform, artificial intelligence platform.
I have one comment to make that I think is important for parents and interested people that want to look at the IEP and determine progress for the student. I advise many of my clients to look at as I mentioned before, the reporting page on your goals and objectives. Many times I see that is marked very superficially without specific data to evidence the fact that the child is meeting the criteria as stated. And so you want to be sure at a whatever meeting you're at, if it's at a PPT or even just a team meeting, and they are discussing the student's achievement on those objectives, you want to ask for what evidence, what is the data that supports the fact that you're saying that my son or daughter mastered or achieved these goals. It's amazing to me that many times I see it's checked off, oh, they mastered, but there's no supporting evidence. And so you want to be very keen and very alerted to the fact that you are entitled to evidence that your child has mastered, and by what criteria your child has mastered those goals. So I think that's just a hint on how to look at that document, because it's not that user-friendly, in my opinion. So.
The other
No.
thing that drives me absolutely bonkers is when I see an objective is written with mastery at 70%. And I had this one time for a student who had a short name, and there were not many letters in their name, and it suggested that they would have mastered spelling their name if they spelt however many letters, which will completely change the meaning of their name. So the other point is look at the percentages, and for most students, parents have an expectation of giving the child the opportunity to reach their full potential. And some parents might not settle for a C, and our students, we shouldn't just be happy with a 70% pass rate, depending upon what the goal and objective is and depending what the student is. Don't be afraid to say that you want to challenge and suggest that mastery might be when they've got 90% of that goal mastered versus 70%, which is quite often the very low bar that is set, because to know 7 out of 10 of your numbers makes a big difference when you're doing mathematics, and the same with writing and literacy and things like that too.
Yeah, I also want to share, we're, I think, in our 3rd year of the new IEP format here in Connecticut, and a lot of data, measurements, information in the old IEP is lost or it's blended in. There were some improvements, including the font size. That was one of my many comments on the IEP, put it at least 10 or 12 point type because it was much smaller. But a lot of data is lost. A lot of goals are more generic, and it's important that you request work samples, logs of service hours, not just wait for the curriculum-based assessments, beginning of the year, middle of the year, end of the year. There are multiple ways that you can establish meaningful progress or a lack of meaningful progress or no progress at all. We had a question come in on physical education in the Q&A section. For that person, physical education is part of an IEP if a child has an IEP, and it has to be appropriate. And if a child has some limitations, it's advisable to explore adaptive physical education, sometimes referred to as APE. Usually an orthopedist, a physical therapist, or others might be making those recommendations. So if your child has some physical limitations, they might be injured with playing ball, then another way of participating in physical education should be explored. So it is part of an IEP. In Connecticut, I think there's a box on the IEP. Is it regular phys ed or adaptive phys ed? And so don't be shy in requesting alternatives to the regular phys ed program, but you may need to have assessments or other information to establish the need for adaptive physical education.
This is a question for both of you, and it came in before tonight's webinar. It's regarding a child has a complex medical history, and the family would like to know how a school can educate a child if they are receiving hospitalization or some kind of treatment. And I know that more recently I've had quite a number of these scenarios come across my desk, sadly. Any suggestions from Allie or Lawrence?
Well, I can begin as a former public school administrator. I've had the opportunity to work with medically fragile children. So the first thing we should know is that yes, the school district is responsible to provide instruction, educational instruction. Not medical, but educational instruction. They also are obligated to provide accommodations. So whatever those instruction components are and accommodations, it needs to go through a PPT, like any other services for any student that has any kind of impairment. A medical impairment is under IDEA, the Individual Disabilities Educational Act. It is a category under IDEA that a student is eligible given that they meet the criteria. So the student given an IEP would have services, educational services, if they are medically fragile, even in the hospital or in the home. A way to really explore the needs further would be to ask for what we call a pediatric developmental evaluation. And a pediatric developmental evaluation is most likely conducted by a developmental pediatrician that specializes in this type of medically fragile disabilities. So given that evaluation, I think you would really get very specific and explicit understanding of what needs to be provided by the school, where it needs to be provided in the home, the hospital, the school setting, and how. Oftentimes, these medically fragile students need medical service people within the classroom if that's where they're serviced. So, and that goes under the accommodation. So it is part of the PPT, but there are steps to take to really determine all those components.
And just to add to what Allie said, we have something in Connecticut called homebound instruction, which includes hospitalization. So working with having the school district work with the hospital or the medical facility, if the child is in a medical facility, is very, very important to make sure that there's a continuity of instruction, not just sit in front of a computer for 2 hours a day and answer, some online instruction. So I also add, if there are educational services, related services, physical therapy, occupational therapy, speech, some of that might be medical, which isn't part of the IEP, and part of that might be part of an IEP, which is educational. So you want to make sure that the services in the IEP continue as much as they can. You want to make sure the academic instruction is appropriate. Maybe we have a tutor, maybe we have a teacher, maybe the hospital or the medical facility has their own staff. I don't have a broad brush. It's an individual. Some places they use computer-based instruction. Some places have their own staff, and they work with the school district to take the curriculum from the school, work on it with the student, send it back to the school to be graded for credit and grades. But the important thing is to make sure you have the assessments. I mentioned we do have homebound instruction. That's what it's called, and that includes hospital-based or medical-based instruction. So knowing your rights, knowing how to access those services is very important.
I just want to add one thing to that, Larry. You may also have the option, and I know I've seen this done, where your child could receive instruction either in the hospital or at home, and a video camera can be set up in the classroom. So the general ed teacher and special ed teacher within the school can be providing instruction through technology. So that is, it's not all the time, but it can be an option, and you should be aware of that's a possibility.
We just had a question come in to say, is there any limitations with homebound instruction if the student is in pre-K?
Special education starts at age 3 and it ends at the school year or student ages out when they become age 22. So I don't know where that information is coming from. So if a child is eligible as a preschool child starting at age 3 and they're not able to attend a preschool program for whatever reasons, and there are, in the homebound regulations, they talk about a, quote, verified medical reason, end quote. And a verified medical reason can be medical, can be psychiatric, could be psychological, but it's just called a verified medical reason. And the parent, and in particular the physician, it's a medical doctor, not a psychologist, but a medical doctor that has to complete a form for the school district. And part of that form is explaining why my patient cannot attend school and why, in my professional opinion as a physician, I'm recommending homebound instruction for an hour a day, 2 hours a day, whatever the doctor is recommending. And that there has to be what's called a conversation between the school nurse or the school health professional and the physician completing the form, who's recommending homebound instruction. In Connecticut, we have a separate due process hearing procedure should there be a disagreement over the provision of homebound instruction. So again, knowing your rights, knowing the law, knowing what the, and I've had many parents say, we ask for the homebound form, oh, we don't have one. They do have one. It's in the state law. The school districts have to have a form. Maybe it's not at the special. I have one school district, the form is in the school, the town's health department. The school nurses come from the health department, they don't work for the school district, they work for the town health departments. So, so knowing the bureaucracy in your local community is very important, and knowing your rights is equally important.
Yeah, I've had some little ones, a couple of 3 and 4-year-olds that required intensive support in the home environment from the school district. So just know that I've done it for students as young as 3 and 4 for prolonged periods of time because of their unique circumstances. But talking about this time of year, we just put the clocks forward. So ESY is around the corner, and some parents are asking, when could they reasonably expect to be informed if their child is going to be eligible to participate in this year's ESY programs? If they have an annual due in May, do they need to wait until May to find out?
One answer to that, and I see Allie is anxious to answer, so I'll be very brief. You want to collect data. You as parents want to collect data because ESY is based upon a recoupment regression analysis. And if a child has an absence from school, say a long holiday weekend or a long Thanksgiving holiday weekend or a long spring break, and they return to school and it takes a long time for them to recoup those lost skills because they lack the structure, whatever is getting in the way. That's very important data to bring to a PPT meeting. Another way of looking at it, after summer vacation, if your child is ready to return to school within a few days after the first day of school, like everybody else, there's no regression. But if it's taking a long time to recoup skills, in other words, they're ready for school in October, not in September, that's the important data that helps contribute to the discussion on whether or not a child should have extended school year services. There should not be any categorical decision, meaning, oh, we don't offer that, for that child's eligibility category. It has to be individualized. And the other part of ESY, it has to be appropriate. The same free appropriate public education standard for the regular school year applies to the summer. It might involve a reduced curriculum or reduced amount of time, but whatever it is, it has to be appropriate. Allie, so you wanted to add something?
Summarized it very well. I just want to comment about some of, the criteria, and you said, you mentioned recoupment and regression. One of the data points to really look at would be the benchmark performance assessment of your child in June. Most schools give 3 to 4 benchmark assessments. So you will have a benchmark assessment in June. Let's just say your child did average, whatever, in the major areas of reading, writing, and math. Then come at the beginning of the next school year, and they went way down. That's a really good data point to look at. If you look at the history, you can say, my son or daughter last year ended this year with this data and then began way down, or a little bit, even somewhat of a regression. That shows that child needed instruction during the summer. Many students do regress to a bit and they catch up quickly, but if there's significant regression, I think that's a really good data point to look at, because some parents don't know what data points, and that's one thing that I think you will find very helpful and beneficial. But going back to waiting from, let's say, if you have to wait from May for your child's annual PPT, you can always ask for a PPT prior to the annual and make that earlier PPT the annual. You can push the PPT up. You can't push it back. In other words, you can do it earlier. You can do the PPT earlier than the annual. So you can ask for one in April. And that could be in an annual in April, even though it said it would be in May. You can ask for one in April and determine ESY at that time. There's no deadline as far as when ESY is decided, but if you feel like you want to make plans ahead of time and you're anxious to know if your child qualifies, get all those data points together. Make sure you have evidence to suggest that he or she needs the ESY because of potential regression, and then ask for earlier PPT.
The other thing too, I've had students who are, for example, they might be in 3rd grade, and we get the report back, oh, they're reading beautifully, they've made such incredible progress. I say, that's wonderful. What grade are they now reading at? Oh, kindergarten. Okay, but they're still not reading at the 3rd grade level. So also, again, the devil is in the detail. It's wonderful if a student is making progress. Maybe the platform that they're using is working, but then we can use this summer month to try and diminish this literacy gap that you wouldn't expect them to be a 3rd grade to be reading at kindergarten level. So also be confident enough to know that would also potentially indicate that there's still work to be done, and the summer might be a valuable time within which to do it. And as we know, most students, if they lack that exposure and that consistency, and also the support from educated individuals, rather than just maybe a parent or a grandparent or a sibling that they're reading to, for example, if it's literacy, you can also use some of those arguments as a reason why you feel that ESY would be important for your specific child too.
We had one person submit a multi-part question this evening, and I'm going to just slice off one of the parts on compensatory education. Compensatory education is a concept to make up for lost time. So if your child's IEP has a certain amount of time for speech and language or academic instruction, physical therapy, and for some reason the staff person is out, they're out ill, they left altogether, and it takes time to hire somebody, you should keep track of the hours in the IEP. So if you're supposed to have a half hour per day, and that's not being provided, you count up all the hours in the IEP for each service, each goal that wasn't provided, and you make a request to make up for the lost service time. I had a case many years ago where I had a PPT meeting in May to plan for the following school year. And the parents called me in the middle of September to say, my child, who was supposed to receive 21 hours from a special education teacher per week, wasn't receiving any of those services. So I asked the obvious question, why? And the answer was they forgot to hire a special ed teacher. And so by the time we got this resolved, that family was owed 200, maybe 300 hours of services by the school district. So we created a bank of hours that we could charge off certain requests to that bank of hours. So do it in writing, make sure the IEP services are being provided. If you're uncertain whether they are, you can request a log. So if the speech and language person is seeing your child a half hour 3 times a week, there should be a log reflecting an hour and a half of services per week.
And just to say that those hours of compensation, if they do start to accumulate and become quite significant, they don't have to just be delivered during the school calendar. They can also be delivered during bridging weeks and during times when for example, the schools might not be open due to vacation days or periods of holidays. So just know that you don't have to make up that time during the school calendar time.
Yeah, you kind of took the words out of my mouth, Jane. I think that I've seen many schools with compensatory hours do them, try to take the hours during the school day, but then don't forget your child is missing instruction. It's got to be taken from somewhere. So if they're taking your child out of, let's say, a language arts class or a reading class, you're doing more harm than good. So, you really have to be alert to find out when that compensatory instruction will be delivered. And if you're not in agreement with that, just like Jane said, you could ask for it after school, weekends, or during the summer. But you really need to be, alerted as to when those services will be added to your child's schedule, because you don't want to pull your child out of a really very crucial instructional time within the school day.
We had a quick question. What does ESY stand for? It stands for Extended School Year. That's the summer programming. And we apologize if we speak the lingo and the acronyms of the school district, but that's what we're forced to do. So ESY stands for Extended School Year.
But most school districts, extended school year, the summer program typically happens within the month of July. It normally is a shortened day. It will not typically reflect the same number of hours that you would be accustomed to during a typical school year. And also the clinicians and the teachers and the specialists might be different team members than the ones your child is accustomed to working with, because not all the team members will be on the same contractual obligations over the summer as well. So just know that it might be more changes, more disruption for your child. And also sometimes the school location might change as well, as not all buildings have air conditioning. So some districts house the students in different school buildings during the ESY period too.
We've had a couple of questions before this evening, and I think 1 or 2 this evening, about collaboration, trust, communication with the school district. I often tell my clients, I work in the spirit of collaboration with school district, which is not capitulation to avoid the litigation. And what I mean by that is it's important to develop a trusting relationship. It's important that there's a back and forth. Whatever happens at home is going to affect school. Whatever happens at school is going to affect home. And I don't know how you develop trust. Trust to me is earned. And if you have confidence in the school administration, you have confidence in your child teacher or teachers, the related service providers, that's good. And if that's not happening, you need to figure out a way to develop that trusting relationship. After all, they have your child 6-7 hours per day, 5 days a week, 182 days a year, and parents would like to send their children off to school in the morning and get them back later in the day, a little smarter and certainly a lot happier than when they left in the morning. And if that's not happening, talk to the principal, talk to the assistant principal, talk to, department head, talk to the teacher. In some states, I think we have it on paper. I haven't seen it in a while. There are what are called facilitated IEP or PPT meetings, where a neutral person will come in to the PPT meeting to try to, facilitate communication back and forth. So it's not everybody staring at each other and a lack of a meaningful dialogue. There's no one way to answer those questions. There's no one way to address the concerns. That's why I try to work in the spirit of collaboration, developing a relationship with staff, more often with the school district's attorney, so we have that ongoing communication.
I think the key to any relationship is clear, concise, and timely communication. So I say timely because if you get an inkling that something is amiss, or that you have a niggle that you think that there's something not being adhered to with your child's IEP, or you see a shift or a change in your child's behavior, don't sit on that feeling. Have the confidence to contact the school verbally, and then follow up in writing to clarify and to investigate what it is that you are concerned about. Because sometimes these niggles that you have, or these concerns that you have, can be addressed immediately, and solutions can be found, and remedies can be put into place quite simply and easily. And the longer we sit upon a problem and don't communicate, more than often it gets to be more difficult to manage and navigate. The other thing too, sometimes when we're in those meetings, it's very difficult to manage our own feelings, our own emotions, and not to take things personally. And that's why sometimes it is easier to have an advocate such as myself or Allie, or an attorney such as Lawrence, to be by your side and help guide those conversations, because we come at it from a very objective perspective, understanding everybody's role within the room, and everybody, what people bring to the table, but also what people should be bringing to the table in terms of knowledge and expertise, and can help you shape those conversations and sometimes reduce the temperature in the room if you've had many meetings where it's become uncomfortable or contentious for different reasons. Any other suggestions, Allie?
Just a brief response. As an advocate, I always talk to my families. My goal is to build bridges, not to build walls. So one of the most successful ways that I work with my clients would be to advocate and to recommend to the school team, as well as to the families, to have team meetings. Not PPTs you need, but team meetings are different. They're much less formal. They don't require certain personnel, and they're, in my opinion, they're more collaborative because you can discuss things. And I also recommend, to develop an agenda, so you don't have to, you just don't talk around in a circle. You get to the points. But the idea of a team meeting is to collaborate, to work together, to show that you as a parent or a guardian are truly interested in working with you as a team, and you engage with each other. So I highly recommend these team meetings. And I know it's timely, but you can do it remotely as well. It doesn't have to be always in person. So team meetings are great. And also communication logs, between the home and the school. But Jane, you mentioned communication is key. It's the way you communicate and how you communicate to build those bridges.
The other thing you can do too, embedded within your IEP, you can also ask for consultation hours and parent training from the related service providers. That is also a way for you to develop an opportunity to create a relationship with those teachers, those providers that are working directly with your child, and also for you to feel comfortable enough to ask questions and to be trained and shown specific techniques or strategies that they're using in the school environment, so you can generalize those into the home environment and use those training opportunities as a chance to problem solve together if you're finding things are not as effective out in the community or your home setting, but they're having success in school. So that's also another opportunity to, again, reestablish a different way of communicating, a different channel of communication.
We had a question come in this evening about school-based observation by advocates and others. I just have two remarks. Look at your local Board of Education policy on school-based observations. And the other suggestion is, in Connecticut, we have a publication from the State Department of Education, which is found at ct.gov. That's the state website. It's on guidelines on independent evaluations and in-school observation. There's a lot of good, useful information in the guidelines. Part of it is for independent evaluations, and the second part is school-based observation. Because often the schools will either say your presence in the classroom can be disruptive, or we have to preserve the confidentiality and privacy of the students. But they observe the child in a classroom, and your professionals should be able to have a comparable, maybe not the same, but a comparable opportunity to have an in-school, in-class observation.
I've been fortunate enough to do in classroom observations at schools, and the school is aware and familiar with me as an advocate as well as an educational consultant. And I've also tried and have the opportunity to, if relevant, to observe a child, maybe having a private therapeutic session as well, if there's strategies that are working there that maybe the school aren't aware of, or maybe weren't incorporated within the school day or the school program. So those first-hand observational experiences can be very helpful as an advocate potentially, or if you have external practitioners working with your child in a specialized area too, to have that opportunity to talk to the related professional practitioner within the school district as well, and to sign that permission and that release for those conversations to occur and take place too.
We had a question come in about mediation. Mediation is part of the dispute resolution process. It's informal. In Connecticut, we have a third-party mediator meeting with the family and the school district to try to reach an agreement. The question was, do I have to abide by the decision, or can I appeal? Well, if you sign a mediation agreement, it's kind of like a contract. And usually one provision in the contract, the mediation contract, is either party can go into court to enforce the terms of the agreement. You're under no obligation to sign an agreement or accept an agreement that you don't agree to. And if it doesn't feel right or you don't understand it, it's probably advisable to speak to an advocate, an attorney, or some other knowledgeable person before signing the agreement. I've seen parents all too often sign an agreement that they don't understand, and I'm not in a position to undo the agreement. It's the agreement. It's signed, sealed, and delivered by both parties. It's a contract, and the only way around it is to basically file a lawsuit in state or federal court. So before you sign anything, make sure you understand it. And if you don't understand it, don't sign it. You have questions on the agreement, see if you can find a trusted person, an advisor, a lawyer, an advocate who can answer your question.
We had a question, how can parents ensure the right goals within their child's IEP when they're transitioning to middle school? The answer is, irrespective of which grade you're transitioning to, you always want to make sure that the goals are relevant and appropriate for your child, whether they're transitioning from one school to the next. The difference would be if you're transitioning teams from an elementary school team to a middle school team, you'd normally have a transition team meeting and PPT meeting where the new school educators and team would come and meet with the existing team and share that knowledge, and put those pieces together so that they are familiar with the child before they start in the new school program or location.
That's excellent advice, because I've been involved with all too many cases where the elementary school team will write the IEP, send it over to the middle school, and the middle school said, this isn't our program. We don't offer this, we don't have this kind of service, or we have larger classrooms or more transitions, or the schedule changes. So it's excellent advice to make sure at the PPT meeting, you have the sending school district, the elementary school, and the receiving school district, the middle school. And for the parent who's also expressed a concern about the peer group, just remember the least restrictive environment. Children with disabilities, IEP, should be educated alongside children without disabilities. It should not necessarily be a segregated program within a school unless there is a compelling reason. In other words, some mainstream classes, some specials, access to physical education, art, music, things like that. And again, this has to be individualized, not a categorical decision. We don't look at the child's primary disability and say, oh, you have X, so therefore we're going to place you over here with all other students who have X checked off on their IEP. It has to be individualized.
The other thing I'd like to say, a big takeaway I took away from the COPA conference is I went to a workshop on transitioning and transition programs, is that you have to remember an IEP is not just about a child's education. An IEP and FAPE is also about trying to make sure that these students, when they are completed with special education, that they are able to engage in either further education, meaningful employment, and the ability to live as independently as possible. So when you're developing your IEP, always try and think in the micro and the macro. What is it that this individual child is going to need in the short term and the long term? And you're never too young to start having some of those other conversations and building some of those pieces into the conversation and into their repertoire of activities within a school environment too.
Just to add to that, to really understand if the goals and objectives are appropriate, transitioning or any time, I always ask my clients to request draft goals prior to the PPT. I think it's really important that you as a parent or guardian are prepared for the PPT and have the time to look at those goals and objectives through a microscope and compare those goals to last year's IEP goals, to compare those goals and objectives to your child's current levels of functioning. That meaning at what level, what is the baseline level that your child is functioning at each individual for each individual objective. So if those objectives get repeated from one year to the next, the same objectives, they're not appropriate. Okay, they're not, because the objectives are meant to be achievable. So if they didn't achieve it in one IEP year, what makes us believe that they're going to achieve it in the next IEP year? We have to break down those objectives and make sure that we didn't miss an incremental step along the way so your child can achieve mastery of those objectives. So take the time and examine those objectives. Don't be sidetracked at a PPT and be given those goals and objectives for the first time glance, because even I, as an advocate who is, I'm pretty, versatile in reading an IEP, when you are given something at that particular moment and you have to internalize and understand it and think fast, you may miss something really important. So get those objectives in a draft form prior to the PPT. It would really be a big help.
Yeah.
Oh,
sorry, I was just
wanted to add, and if you can't multitask, read a document that's handed to you during the meeting, just say, I'm requesting an adjournment. and let's reschedule when I have a chance to review and process what you're handing to me. And that's why I always ask at least 3 school days before the meeting that whatever documents the school is going to use, please send my clients and myself a copy.
And to Allie's point, I had one student that came across my desk, and bless them, on their IEP goal for 3 or 4 years, the OT goal was to tie their shoelaces. And so much time had been spent for this poor student who was unable to still, after 3 or 4 years, tie their shoelaces. And so that was missed opportunities in terms of keeping that goal on the IEP versus working on other skills which could elicit, crossing midline and the bilateral movements and all of those things. So also, sometimes we need to be careful about what it is that we are asking the school district to focus and work upon. And how we are using that time, that educational time as well.
And I just want to add to something Jane mentioned before. The eye on the prize is your child's life after high school. And it's very important. In Connecticut, we start transition planning. This is the post-secondary transition planning for employment, education, independent living, starting at age 14, which is often middle school. Now, we may not have a full idea that the child is going to go off to college and become competitively employed at age 14, but we have to start somewhere. And the law in Connecticut is age 14. And there are transition assessments, and we had several questions. There's another guideline on the State Department of Education. ct.gov is the state website. That's also the state website for the independent evaluation and observation, school-based observation website. And you can see, by way of example, some of the tests. These are norm reference tests, standardized tests. Sometimes it's a situational assessment. You place a student in a particular environment and see how well they do. Can they handle a consumer transaction? Do they know they have the social cues in a restaurant? Whatever is an appropriate transition assessment, because we've decided we need to work on academic skills, executive function skills, because they're going off to college. We have to make sure they're intact. Or they need to work. My favorite story with employment, many years ago, I had a client that thought his employer was stealing from him because nobody ever explained the concept to him in high school, gross pay and net pay. And he thought his employer was stealing and didn't understand the government takes taxes and you have to pay for insurance and there are other deductions from the paycheck. So it's things like that you want to make sure that our now soon to be young adult who's exiting special education at the school year they turn age 22 or when they graduate, that they have the skills to go off to college, or if they're going to a vocational school or a community college, they have the ability to navigate their community, go into a restaurant, they understand money management skills, they know the difference between 911 and 211, for example, public transportation versus getting a driver's license. Can they cook meals, maintain an apartment, pay rent, whatever whatever need has been identified in the transition evaluation, that has to be worked on.
Just have one thing to add to that. I've seen many transition goals with evaluations that have been planned, but they are evaluations that are planned for all students. In other words, all high school students, go through, many of them, like with the guidance department, they will do a program called Naviance, let's say, which is kind of like a interest related, what you're interested in, or, and those kind of strengths and areas of need, whatever. Those are for all students. I'm not saying that students with IEP shouldn't have that, but The I in IEP is individual. So what you really need to look at is not just what all students get, but what your particular student needs. What areas do you want to focus on in your transition planning? That will dictate and determine what transition evaluations need to be done. And looking on the state website is an excellent resource. They have all of the, not all, but they have many transition assessments listed by categories, so you can really determine which ones would be appropriate for your child. But remember, it has to be individualized. You don't want an evaluation that is just for all students, because you're going to be missing some really important determining factors there.
We've come to our end of tonight's webinar. Excuse me. No, we've come to the end of tonight's webinar, excuse me. And we've gotten to most of your questions, and if we didn't, I apologize. So I want to thank Allie for her generosity of giving of her time and her advice, and Jane as well. Jane and I will continue our webinars as we're moving forward. We don't have the next one scheduled, but we will send out an announcement for the next webinar. We're identifying a topic and trying to locate a speaker at the same time. If you found tonight's webinar informative, we welcome your continued participation and support. We have a YouTube channel for the Law Office of Lawrence Berliner that has the recordings of the webinar. As I mentioned, if you're registered, you'll get a copy of it. And I want to thank my daughter, who's off to my right, who was giving me a high sign for something, who makes these webinars available. She handles all the logistics, the electronics, the invitations, and without her, Jane and I could not do what we're doing. And without Allie, we can't do what we're doing, and we very much appreciate your participation. So those are my concluding remarks. I want to thank everybody who was here, your valuable suggestions and questions. And Jane and Allie, have any final thoughts?
Yes, so there's a couple of things I'd like people to be aware of. So at the Stamford JCC on March the 30th, which is a Sunday, we are hosting a special education resource fair in partnership with the Special Education Legal Fund, that is SELF. So the resource fair will be at the Stamford JCC. We currently have at least 45 vendors, if not more, attending the event. There will be advocates, attorneys, special education schools and different related practitioners, maybe therapists and all sorts of individuals there that you can come and meet in person. And we are also going to be hosting some panel conversations during the resource fair, and it'll be a nice opportunity to meet some of you that have been avidly following our webinar series over the last 5 years. And in addition to that, if you check out JumpStars, we have some fun recreational programming and opportunities to get together with other parents and caregivers at no expense or cost yourself. And you can find that information on the JumpStars social media platforms. But it's been a pleasure to be here this evening. It'd be lovely to have Allie back again for some more roundtable conversations, and I look forward to seeing you all soon.
Thank you. And I just wanted to say thank you for inviting me here. It's one of my favorite times. I love working with both of you, but also knowing that the people out there are, hopefully are benefiting from some of these questions and answers. And as an advocate, I see, a lot of difficulty with parents and families navigating through the system. And hopefully some of these answers will help you through that difficult process. So happy spring, everybody, and enjoy the nice weather, and hopefully we'll see you soon. Thank you.
Good night.
Good night.